The allegations are that the defendant was extremely intoxicated with the 9-year-old and the 8-month-old present, and then strangled.
She's sober, she's clean, she's getting treatment. We have this letter from her treatment provider.
The only way I'm signing off is because she's on a GPS right now. The only way I'm signing off is the other ankle gets a scram tether. But I'm going to put all the guardrails and safeguards in place that I possibly can before that happens. Court calls the case People versus Shantia Holloway.
Lord Yaki, Assistant Public Defender with and on behalf of Ms. Holloway, who is approaching. Take your name to the court. Holloway.
Thank you.
Your Honor, in terms of the next steps in the case, we are requesting that this be set for preliminary examination, but we do have a bond argument that I would like to make.
Discovery is complete.
To our knowledge, Your Honor, yes.
All right. And people have their witnesses available the 19th. I'm sorry, I didn't. Okay. Preliminary examination, May 19th, 2026, 9 a.m. as to bond.
So, Your Honor, Ms. Holloway is currently on GPS tether and prohibited from returning to the residence. This is obviously an allegation involving her oldest child. Her oldest child does not live at that residence currently. I verified with the DHHS worker that the child who's the complaining witness in this case.
I think I heard this the last time, didn't I?
This is her first PCC, Your Honor.
Is it? Okay. Sounds familiar.
But so the child who's the complaining witness in this case is in Pontiac with her mother, and she understands that we are not asking for that.
Whose mother?
Ms. Holloway's mother.
So the child is with grandma.
Correct.
All right.
She's not asking, we're not asking for any contact with that child or for her to be able to go to that residence. What we're asking is for her to be able to go back to where she was living before. Her youngest daughter, who's 8 months, Aurelia, is there. And
Months old.
What was that?
Months old.
8 months old. And that's the issue. I was finally able to actually have a conversation with the DHHS worker who's investigating this, and I have some documentation here. She supports her having contact with her baby, who's not a witness in the.
Okay. What's the people's issue with the one child is in Pontiac, or do you not know that?
No, that her child was with her right with the because the allegations are that the defendant was extremely intoxicated with the 9-year-old and the 8-month-old present, and then strangles the 9-year-old calls the police, and then is prosecuted to the point of belligerence. And then the 9-year-old says, she's my arms swinging me to the point of unconsciousness. So I have concerns with, at minimum, obviously strangulation accusations, and then the fact that she was drinking so heavily while these two children are in her care, especially an 8-month-old who would need her to be sober and competent. So I think at this point I'm going to object until we move to preliminary exam and see what happens there, and then maybe reconsider having contact with the youngest child.
May I respond, Your Honor? So first of all, Ms. Holloway is testing on a sober link twice a day. There's been no violations. We do have documentation that she sought treatment for alcohol use. She's sober, she's clean, she's getting treatment. We have this letter from her treatment provider. We also have a couple other letters from the director of her baby's daycare in terms of
That's all fine and dandy, but CPS you're saying is saying what?
So the CPS DHHS caseworker said she supports her having contact with the baby. They're not recommending any restriction on that. They are recommending.
Well, there's a difference between having contact with the baby and caring for the baby.
That's exactly true, Your Honor.
I know, I said it. So
my understanding is, and I clarified this with Ms. Holloway, you're not going to be actually living there, staying there. You just want to be able to see her and be able to go back there.
Who's the baby with?
Her father.
The baby's father.
Correct. So she just wants to have contact. She's not looking to live there and to actually be the sole caretaker. She's just looking to be able to see her.
Have they arranged any, I mean,
Safety plan in place for procedures.
Miss Holloway's been working really closely. I do have her information. She did not give me anything in writing because it's an open investigation.
I will say, for example, that if I received some information from CPS as to this, I think I'd be willing to agree to her having like supervised visits with the child, but I just don't have any information to.
right, that's my understanding, Ms. Yagi, is you wanted her to go back there to be with and care for the child. I don't think, given what I'm hearing, that I would do that. But if there is the notion that and there are those that are saying she should see the child, I also don't fundamentally have a problem with that. And I think that that's probably a good thing. But it's what are the parameters of that, which is part of the problem that I'm having. I don't know what I could fashion necessarily to do that without some input as to what that contact would look like. You know, are they saying, so they're not objecting to the contact, but are they saying she should see the child once or twice a day, or are they saying, what are they saying? I don't know.
So Ms. Holloway is saying that one suggestion she had is she has godparents who she's living with now, who one of whom is here in the courtroom. He is very supportive, but also very tough. I mean, he is very wants to make sure that everybody's safe, wants to look out for the baby. Ms. Holloway wants to make sure everybody understands the
I don't have none of that, Ms. Yagi, am I having an issue with? I just need somebody to give me a recommendation as to her seeing her 8-month-old and what that looks like.
Safety.
Yeah, I don't, because otherwise me trying to do anything, I'm stabbing in the dark, and I'm not going to do that.
Okay. Your Honor, I will develop one and I will send it to the people and seek a stipulation. And if we are able to come up with something that is, could I submit that to the court via writing, in writing for an order?
Submit what to the court?
So for example, if I speak with Ms. Holloway and she suggests, for example, visits at a certain time, while, you know, either the child's father or her godparent is present, something like that with more specific.
If those individuals, whether it be in the form of a safety plan or there are other individuals that have put together a way that this would happen, then I'm not going to have necessarily a problem with it. I don't know that the people would either, based upon what was last said, but I don't know, again, I don't know what that looks like. So I'm not agreeing that I'm going to sign anything without seeing it and seeing where it comes from. It can't come from the defendant of what she would like. It has to be something else that, well, she may like it, but somebody else is going to have to sign off on that. I'm not.
Understood, Your Honor. I will follow up with the DHHS caseworker as well, and maybe if I can get her email, you know, input, I can submit that to the people, and that might carry more weight than.
Right. Here's the other thing, though. The tether she has on is a GPS tether.
It is, Your Honor.
Do you have any indication as to what her VAC was at the time the police arrived?
I'm not sure. There's just a note that if you're highly intoxicated, it was unresponsive to questions.
Okay. So once you figure out what that may look like, the only way I'm signing off is because she's on a GPS right now. The only way I'm signing off is the other ankle gets a scram tether. Because I'm gonna make sure there's no drinking.
Understood, Your Honor. I will, and Ms. Holloway wants me to, make sure that I say to the court that it's, the tether is interfering with her work because she gets to, charge it and she works in plant and, but the court had, it sounds, the court is not willing to remove the GPS tether at this time, but I will follow up with you and we'll seek a stipulation from the people and submit something to the court.
And all I'd say is a lot of this interferes with a lot of things that others have to do. And so I get that it's an inconvenience, but I also am aware, at least as I look at this case, that there's an 8-month-old that I'm sure you would like to see. I'm sure she would like to see you, but I'm going to put all the guardrails and safeguards in place that I possibly can before that happens. Plain and simple, inconvenience or not. Near examination, May 19th, 2026, 9 a.m. I'm going to put that before me. Thank you.
Thank you.